denied permanent commission despite a judgment of this court giving her that relief. We are in contempt, my lords. But my lord, consider listing it next week because she's been out of service for 4 years today, despite a judgment in her favor. So,
which matter?
My lords, I've got the name here. Seema Chaudhary. It's actually
permanent commission has been denied for Army officers. Which part of the force are you talking?
The naval force. It's the law department, my lords.
Navy.
Yes, the naval force.
Probably that matter is covered by the arguments we have heard.
It should have been covered, but in contempt. She's still out of service today. So we are before my lord only. That's why I'm mentioning it, my lords. Either next week or in first week of January.
Anyway, next week, just list the matter.
My lords.
We will tag it with the matters judgment we have already reserved.
This one, my lords, is a standalone matter. It's a standalone case and we've been granted relief as a standalone case.
We will hear for it.
My lords, if I may mention a matter,
Mentioning.
My lord, I'm aware of the circular, but I assure the honorable bench that this is for a fresh listing.
Tell us what is the exception.
My lords, there is a matter that's already listed and it is scheduled for 5th of January 2026 for the hearing. And our matter is also a connected matter in the same thing. Your Honor, my lords, if you allow, could we please...
So you want to be tied on 5th of January?
Yes, my lord.
But there is no need of mentioning that. You could even a simple 2-line letter is sufficient for this.
My lords, we've gone to the appropriate bench and we have been told that without directions from my lord.
All right, done.
Thank you,
Next.
Lord.
May I mention a matter, my lords? It's an extreme urgent matter, my lords. The demolition matter, my lords. The demolition is ongoing, my lords, by the High Court of Jharkhand.
Have you removed or cured the defects?
But demolition has been 72 hours in block demolition order.
Have you filed a petition?
Yes, my lords, that has already
Have
been
you
filed.
cured the defects?
My lord, my lords, the defects, my lords, the similar tagged matter has already been listed. My
Cure the defect. Without curing the defect, we are not going to list.
My lord,
Cure the defect.
my lord, 72.
the order that said the demolition should continue, the order that came for demolition passed yesterday, and 72 hours have been given, Lord. And the
Order of demolition is passed?
yesterday my IA was dismissed, and that order we could not annex, but we have annexed the main order of 3rd December where they say...
I don't know what kind of artificial urgency. Monday ko laga do.
My lord, similar matter has already been listed today, my lords, under defects, my lord.
Make a mention there, no difficulties.
Let
then
it,
Monday...
my lord, let it be listed on Monday.
No, Monday we can list.
Monday.
Monday, let it be listed on Monday, my lord.
Yes, item 1.
Please,
My lords.
one. Yes, I'm appearing for the appellant. Item 1. That's.
What is the urgency?
Just see the photograph. His house has fallen down. The roof has gone.
Because we have photographs to show that he's rebuilt it.
Dispute over a house and...
I think this will be heard in January. Fix the date and hear it in
I have no difficulty.
or February.
Early hearing, we are fighting like this, please.
I'm not fighting. Just see his photograph at page 21. I will not say anything beyond that.
Discuss person.
Let's have said for January with any date.
We'll see what.
Please.
I'm grateful, deeply obliged.
Next item.
Item 2, my lords, learned AG is online.
Your Lordship faces. Your Lordship recollect on 8th we had another matter where that was in the context of education. That was in the context of education. There is a mistake in this case. In paragraph 3 at page 3, the High Court says it is a case of admission to educational institution. I am told that is not correct. He is seeking employment. Therefore, I told you last occasion there are 46 such petitions which are pending in the High Court and here. Page 3, paragraph 3.
Page 3 says the petitioner seeks admission to education.
That's incorrect. He is now on a employment situation. So therefore, there are large number of issues that come up on the question of whether certificate on the basis of mother's origin will lie or not. Therefore, item 19 is also on the same footing.
Yes. Item 19 also same.
Yes. And your Lordship have issued notice and tagged few other matters which, Mr. Arvind, please hand over that copies. There are a number of petitions which are pending.
Office report says that.
The 2003 view.
So that's why in the last occasion, educational institution, I did not oppose.
Or the argument that the caste certificate must be based upon paternity. That is
Yes, Your Lordship, please.
Frankly speaking, we are not agreeable to that, and if need be, we will refer to a larger bench.
No, there are a number of Government of India's instructions, the Home Minister's instructions, which govern the field, which says that it was on the basis of the father's. So that's a law which prevails today, unless that is set aside. Because unless that is set aside, finally will lordships. Therefore, Government of India's instructions govern the field. Lordship may have to consider this issue.
Issued in which item?
The fresh items, my lord. Both are fresh items.
And then the other issues in the connected matters were being tagged together. I think number of matters are there.
Are you referring to this SLP 56593?
Item 19 on your Lordship's board today is also on the same issue.
Yes, 19 is there, but 19 also.
Yes, yes.
Yet to be issued.
Is there any matter?
SLP 33312, 33311, and SLP three more SLPs are pending, my lord, after notice.
No, which is it? Which
333
one is the SLP involving the identical question?
Yes, your Lordship. So on the question of mother's certificate, the question of mother's origin.
What is the number, please?
SLP civil 33312 of 25, 33311 of 25, and give me Pratibhasan.
Please hand over a copy of those orders.
I'll just hand over to the court master.
Say issue notice returnable on so-and-so date. Tag with SLP number so-and-so. All the matters are directly to be listed before this bench. On so-and-so date. The respondents will serve through thus the notice.
It will also be, I think, advisable if the matter is disposed of early, maybe in February or so, as soon as the list. Yes, yes.
Meanwhile, in all such, both the 19 is also for employment.
Yes, ma'am.
Yes, yes, 19th also employment. I found out that is employment.
Like,
The report is there.
since the present case does not pertain to seeking admission in education institution, the parties are directed to maintain status quo. The issuance of certificate. Item 2, probably you have already issued certificate.
Yeah, the certificate has been issued because therefore certificate has been issued, but the question of taking benefit of the certificate may not arise at this stage. That's about all.
Then we need not to issue any interim direction today. We can first hear them.
Your Lordship, please. Yes. Right.
Issue notice them, say Dusty person. So keep it in January 2nd week.
Much obliged.
Grateful to your Lordship.
Give them, please.
Yeah, please, Lordship. Lordship, with utmost respect, I seek your indulgence in this social cause matter where Lordship, this institution.
But please appreciate now every week, in fact, we are getting at least 1 or 2 writ petitions on average basis pertaining to Allahabad High Court.
No.
What will happen?
Lordship,
Virtually, you want us to interfere not only in their roster and docket management, you want us to run their day-to-day listing.
Lordship, it's just not.
See the
personal.
consequences.
Put before your Lordship of a personal cause, Lordship, it's a
No,
social
in your
cause.
case, you said 12 adjournments have been granted. There might be matter where 120 adjournments have been
Find the
granted.
the state advocate.
You are a management, you can afford to come to Supreme Court. What about those who can't?
Lordship, I humbly pray before your Lordship to just kindly direct for the expeditious disposal, Lordship. I just pray for it.
That means only those who are able to secure an order from Supreme Court,
Lordship,
they will have a preferential hearing.
Lordship, I'm not,
What is trend we are going to?
Lordship, I'm not for the personal cause. Lordship,
For 17 years in approaching the High Court. You have waited for 17 years to approach the High Court.
issue stands.
Now you want your matter to be taken out of turn.
Lordship, this issue stands concluded. There are binding precedents on ground, Lordship. Despite that, Lordship, hundreds of students are suffering, deprived of quality education and resources. Lordship, I am not before your Lordship for the personal cause.
The instant petition has the instant special petition directed against an order disposing of early hearing application filed by the petitioner management in a pending writ petition before the High Court. In a writ petition pending before the High Court. In our considered view, the special petition not maintainable. The same cannot thus be entertained. The petitioner may, if so advised, may, the petitioner may, if so advised, approach the High Court along with an application giving full, containing the reasons which may require its petition to be heard out of turn basis. Can be heard on out of turn basis. We have no reason to doubt that such an application shall be considered by the High Court as per its own merits and sympathetic.
So grateful.
May I please, my lords? My lords, my application under 11.6 was filed before Gwalior bench, my lords. Now the arbitrator, my lords, has been appointed at Jabalpur, my lords, which is more than 500 kilometers away. This is going to cause, my lords, substantial.
But
My lords, the parties are at Gwalior. Sorry.
Sitting in Gwalior also, what is
It would be substantial difficulty for us, my lords. It is more than 500 kilometers away. One day we go back, another day we come back, my lords.
within your state, you are working there, you are
No, my lords, we are working. Parties are residing and working at Gwalior, my lords. The agreement is executed at Gwalior. We file an 11.6.
Under section 22, it's the arbitrator's prerogative upon consultation with parties to decide where they will be the venue of arbitration.
My lords, the venue is at, it has,
And the venue does not affect the seat. Then
my lords, the venue, my lords, it has been Jabalpur Arbitration Center. That has also been fixed.
For that you approach the arbitrator, make out a case, whatever hardship you have.
My lords, from Jabalpur to, my lords, from Gwalior, this is 500 kilometers. It will take 3 days for us, my lords. Both the parties will have.
Difficult work can be done.
My lords, we only pray, my lords, let it be, because the 11.6 was filed at Gwalior, my lords, before the Gwalior bench. The order has been passed.
If the Supreme Court will start interfering, then what will be the end?
Lords, that would be-
Within your state, without affecting the jurisdiction, without affecting anything, only A place to B place.
My lords, if it would have been, my lords, 100 or 50 kilometers or 200 kilometers, we wouldn't have come, my lords. It would be effectively, my lords, one day going, another day, my lords, coming back, my lords, the parties, the councils.
Petitioner, at a considerable length, we are not inclined to interfere with the order of the High Court, in terms whereof the High Court has declined to interfere with. The High Court has appointed the arbitrator and permitted to conduct the proceedings at Bhopal.
At, my lords, Jabalpur, by the Gwalior bench of the High Court, my lords.
At Jabalpur.
Madhya Pradesh arbitration.
Under the aegis of Madhya Pradesh Arbitration Center in the domestic and international at Jabalpur. The petitions showed agreement that the arbitration proceeding should be conducted at Gwalior instead of Jabalpur. Promise an issue that can be effectively raised before the for consideration of the learned arbitrator. With the liberty of ordinance, committee specially petition declined.
Subrat.
Please, my lords. My problem is the stigma. My problem is the stigma. Please, my lords. The point was that I had offered to voluntarily take retirement. My writ petition also was pending. The writ petition was not heard for 17 times. And in the meanwhile, my lords, this compulsory retirement. This is something, my lords, that
Some message should go in judiciary. Otherwise, some message within the institution is required to be sent. Sometimes we find people who are unfortunately on the wrong track. There is no way out.
I agree, but my lords,
The system has been very accommodative as far as he is concerned.
my lords, here,
Obviously, on a corruption charge, instead of levying the punishment of stoppage of 5 increments, he could be thrown out even at that stage.
my lords, here,
No. Either way, it could be justified. Instead of 5 increments, suppose there was an order of dismissal from service. Probably, no court would have interfered. Because it was not a punishment so gross or disproportionate.
in a sense, 5 increments lost, then compulsory retirement.
Compulsory retirement is, compulsory retirement is not as a measure of punishment. It is only when you reach the stage of 55 that your entire service record is, overall service record is to be taken into consideration. There, if you have the punishment, a checkered service record, then bound to not a case where you should insist or we should interfere.
I'm sorry, my lords. Yeah.
Not a case where you should insist or we should interfere.
Let me go to the High Court and then try this. That's the only thing, because I've come here.
See, in fact, he had filed a petition.
So the petitions at the outset seeks and granted permission to withdraw this petition with the liberty to approve the High
I'm grateful, my lord.
Court report.
Your Lordships, I seek indulgence of your Lordships in this matter. I am an innocent home buyer who purchased this flat back in 2014. And I have still not got the possession of this land. And there are...
Is one flat or more than one?
One flat.
One flat.
One flat. And there are many similar matters also, as I would like to bring your Lordship's kind attention towards.
First, we would like to hear the facts of your case. So you purchased one flat, then what happened?
Back in 2014. After that, I purchased this flat for approximately 74 lakhs. I have still not got the possession of this land. And the banks have...
How much you have paid out of 74?
I have paid 38 lakhs initially. And after that, 52,000 were monthly installments for this flat.
The project was to be completed which year?
It had to be completed within 36 months, 3 years. And it could be extended up to 6 months only.
So 36 plus 6, 42 months, commencing from?
From the year 2014.
14. So that period expired when?
Yes. Yes, Your Lord.
It expired which year?
It expired in
1718.
1718. And till date, I have not got the possession. Banks are...
What is the prevailing condition at this spot?
Pardon?
What is the condition at this spot? Have they constructed? Is it partly constructed or they have not even started construction? or construction is complete, some finishing work is going on?
Your
Any
Lordship,
idea?
the main issue in this matter is that there was there was an agreement between the banks and the builder and the developer and me, the home buyer. So the loan had to be disbursed. The loan had to be disbursed as per the stages of development. But the loan was disbursed in one transaction only. As per the RBI circular of 2014, it was strictly prohibited that the loan amount,
The tripartite agreement between you and.
quadripartite agreement between me, the bank, the developer and the builder.
So
It
what-
was a
so what does
quadripartite.
That agreement say?
Pardon, Your Lordship.
What does the clause under that agreement say?
Lordship. I just
So you can
bring your
use your
kind
own
attention.
words.
Your Lordship, the clause 2 mandated that in the event of default in the payment of installments by the home buyer, the respondent number 2 and 3, that is the builder and developer, would have the right to cancel the same at the request of the respondent bank.
No. What is the obligation with respect to payment of the balance allotment or sale consideration? Is it to be payable in installments? If it is installments, how much is the amount? And if there is a default, then are you liable to pay lump sum amount, or you are liable to pay only with some compound and penal interest?
Your Lordship, as per the agreement, the respondent bank had to disperse the loan amount into various transactions as per the development stage. Supposedly, if first floor of the flat has to be developed, then first transaction will be disbursed from the bank to the developer and the builder. Then as soon as the flat gets developed, the transactions will be disbursed directly to the developer. But I was directed to pay monthly installments of approximately 52,000. So my concern is that as per the RBI circular, which is of 2014, there was the strict direction that this amount, this whole 74 lakh amount cannot be disbursed directly in one transaction. It has been debited into the account of the developer in single transaction. My humble submission to your Lordship is that.
In your case, what have they done? The bank has paid the entire amount in one go.
Exactly, your Lordship.
When it was done?
And now they are seeking.
When was it done?
Your Lordship, in the year 2014 only.
2014.
Yes.
When did you come to know?
Your Lordship,
Did you continue to pay installment thereafter also?
Your Lordship, now they are going to DRT.
I was worried more than you because you are answering every question. So I had to catch hold somewhere. Okay. Yeah? So
Your Lordship, history is the evidence.
all I
that-
issue notice. Issue notice.
Grateful, Your Lordship.
Returnable and so on so that. Meanwhile, no coercive action shall be taken against the petitioners. Similarly, there shall be first charge on one of the apartments in the subject project exclusively earmarked for the petitioners.
Grateful, Your Lordship.
Good. Keep it like that. Tag with that.
Please, Your Lordship. Your Lords, the division bench, my Lords, doesn't consider my appeal at all. I have a statutory appeal under Section 10 of the Delhi High Courts Act. The division bench, my Lord, not only does not even consider the correctness of the order, it doesn't even pass one sentence saying we agree with the prima facie finding. Merely says, because there's a prima facie finding by the single judge, your appeal is dismissed. Please see, my Lords, the order. It's a laconic order with great respect.
Ad interim injunction matter. What else? What kind of findings you expect from the High Court?
My Lord, at least to hear me on the prima facie case.
These are very frequent situation the courts face. If you disclose your mind, you are caught because you expressed opinion on merits. If you don't disclose your mind, you have not applied your mind.
May I answer, my lord?
So this application and non-application is a very
I understand where your lordships are coming.
balance has to be maintained.
I understand where my lords are coming from, but the point here is, a learned single judge considers a prima facie case. He comes to a conclusion. I have a statutory appeal saying, and the only reason on which my prayers are rejected, 39(1) and 2. Only reason it is rejected is that the learned single judge says, I don't agree with your prima facie case. Doesn't go further, because I agree. Once you say I don't agree with your prima facie case, question of going to balance of convenience, irreparable hardship does not arise. There I have no quarrel. So the whole issue is, have I established a prima facie case or not?
No.
I come on appeal against that. If your lordship would permit me to just read this part of the order.
So once you establish a prima facie case, the court is expected to call upon the other party and proceed on the premise that it will require adjudication on merits because prima facie case is made out.
Absolutely.
Right.
Now, my lord, learned single judge dismisses my 39(1) and 2 on the ground, I don't see a prima facie case. I have a statutory appeal under Section 10 of the Delhi High Court Act. I come up on a statutory appeal. In the statutory appeal, the division bench would hear me on the prima facie case and see whether they agree with the correctness or incorrectness of the learned single judge's order. That's the very least. Here, please see page 3. Page 3, leave aside the fact that there's no consideration at all. Quite apart from that, there is not even a finding that I agree with the prima facie finding. Please see paragraph 4.
Read page 2, the last line where para 3 starts.
Page 2, my lords.
Page 2
An application under order 39(1) and 2 was filed by the applicant in which the learned single judge prima facie interpreted the trustee in observing in paragraph 3. In paragraph 77, interlocutory order is reproduced above. Learned single judge has already clarified that the interpretation is prima facie shall not be treated as final. Learned counsel have been heard. Now, 7. However, without going into the aforesaid issue, this court deems it appropriate to dispose of the appeal with the observation that the interlocutory order passed is based on prima facie interpretation and the learned single judge. My lord, that is a fact. It's a fact. But the point is, then what is the purpose of my appeal under Section 10? Why should I appeal at all? If the conclusion is going to be, learned single judge has found a prima facie case, therefore, then my lords at least say, I agree with the prima facie view of the learned single judge. There has to be some application of mind. It cannot be that single judge has said no prima facie case, therefore, end of the matter. My lord, then why have an appeal? We'll do away with Section 10 of the Delhi High Court Act. And my lord's court has, in fact, taken a view that in similar matters, that some reason has to be attributed. My lord's, your lordship's court. Sir.
He should take it. We are 9 minutes one more.
My lords, kindly see paragraph 2. We have perused the impugned judgment and find that except for placing on record the case of the writ petition.
The point is that what is the relief you are asking for through an interim application?
My lords, I have asked, inter alia, there are about 6 IAs. I had various IAs.
You have filed various applications.
Yes.
Of which probably are still pending.
Yes.
The learned single judge as well as the High Court has clearly observed that this order shall have no bearing on the merits of those 2 applications.
May I?
Which will be decided separately.
Separately.
As per their own merit.
But
now, as far as this application is concerned, let us see what is the interim relief you are asking for.
yes, my lord, page 1 is the relief being asked for. It's been extracted. Page 1, I'm sorry, page 1 is the main relief. The 752, my lords, is the learned single judge's order, page 752. Volume 2 of the special leave petition. My lord, to answer my lord,
interrupt. I don't.
when there are 6 IAs,
He has not challenged the order, he's challenged the finding. The appeal doesn't, and
My
no
lord,
interim relief
when
asked
there
for.
are, I have
He should at
challenged
least
the
point
order,
that
my
out.
lord. He's not carrying the order at all.
Your Lordship may see the prayer in the.
Can I finish, my lord, before my lords give their reply? My lords, the point I'm trying to make out is this. My lords, I'll show your lordships a prayer at page 752. But before that, would your lordships just see this? All my IAs are predicated on these two clauses of the trust deed.
Third IA, which is disposed of subject matter, prayer B is now become academic.
Infructious.
So the only thing which the court could have seen is an appointment of administrator.
My lord, that was the.
You would.
That is the error of the learned.
Administrator appointment required.
I'm sorry, my lord. There is an.
Responsibility.
My lord, that is where the error is coming.
The amount is declaring the suit itself.
My lord, would your lord, my lord, I'll explain where the error is coming. My lord is absolutely correct, except, sorry. My lord is absolutely correct.
In a private trust, requires a watertight case.
My lord, I'm not on that. Would your lordship take just a moment? My lord, can I take one moment, my lord? What has not been made clear from either of these orders is this. My lord, kindly see, there are 5 IAs pending. All 5 IAs are predicated on this very same prima facie finding. It's all very well. The learned single judge, when taking up the other IAs, will go on the same prima facie finding. The other IAs. Have you passed this to the lordship? My lord, please see this. Just one, I've just handed this over. Please just see this, my lords. Single page. These are the IAs pending. As my lord pointed out, this particular IA, which the learned single judge took up, was on the administrator. But he has given, my lord, he has given a prima facie finding on what runs to the root of all my other IAs. Please now see the other IAs. Please just.
Therefore, Mr. Sundaram, prima facie finding means that the court has proceeded to pass an order on merits of that.
My lord, he has not discussed administrator.
It is rejected. You have not filed an appeal against that.
My lord, to answer my Lord Justice Bagchi, please just see this entire order of the single judge.
Mr. Sundaram, the day we all got admission in law, and till date, when we are near to hang the boots, what we have learnt is that the prima facie alone is not the factor to grant an injunctive order. There is something more that has to be established, and then only question of an ad interim injunction order.
Therefore,
Mr. Sundaram, one thing, the word prima facie is a very generic expression,
Yes.
but it must take color from the relief that you are seeking.
my lord,
You consider an injunction, right? The level of satisfaction of the court would be much lower compared to a receiver.
exactly.
When you appoint a receiver, you must satisfy the court of that high degree of interference necessary through judicial.
I would agree with my Lord Justice Bagchi. I agree with you completely. But please see my lord, please see the entire order of the learned single judge, whether there is any consideration of my application. My lord, kindly see the entire order. Would your lordship see the learned single judge's order? Forget the division bench now. Please see the single judge's order. My application, please see whether the learned single judge has even referred to that application other than at page 752. He has not discussed it. There is not even a whisper about my application for administrator.
Which application he has not discussed?
My lord, I'm talking about 752, this appointment of administrator.
So therefore, you are seeking an ad interim direction from the court for appointment of an administrator during the pendency of the suit. Your second prayer regarding meeting of AGM,
Ad interim, my lord, interlocutory.
Mr.
It
Sundaram,
was after pleading.
you asked for two prayers. Meeting of the AGM and appointment of an administrator in that meeting of the AGM.
Yes.
In consultation with the trustees, right?
Administrators separately, including this AGM. Both. Please see the prayer. It's not, my lord, if the learned single judge, please see after this whether he is even referred to prayer A.
If you want to complicate your understanding of the relief you are asking for, that we can't stop Mr. Sundaram as his own.
My lord, can I just place my case very simply for your lordships?
Because you asked for two things, Mr. Sundaram.
One is not considered. A was not considered at all. There is not
considered because consideration of A, if consideration of A the way you want, the manner in which you are wanting consideration of A would result into two things. One, if the court forms an opinion, according to you, prima facie, that an administrator should be appointed.
or that it should not be appointed. The single judge did not go into administrator at all.
With your permission, can we?
I'm so sorry, my lord. Please excuse me.
So if the court forms this opinion that an administrator should be appointed, it amounts to declaring your suit. Therefore, that opinion cannot be formed.
To which
if the court directly says that, no, you have completely failed to make out a case of appointment of an arbitrator, it may also amount to adversely commenting on the merits of the suit. So the court has to navigate very carefully, meaning thereby you have a prima facie case, maybe after you lead evidence, the court may find a case of arbitrator, the administrator.
To which my answer is this. Please just see this. Two answers I have, and I leave it with that.
To proceed.
I have two answers, and I leave it with that.
One application after the other.
My lord, I have two answers, and your lordships, with that I will leave it. My lord, I will leave it with two answers to your lordship, and that's it, and then I would leave it after that. The fact is, as my lord pointed out, I asked for appointment of administrator. My lord, I asked for appointment of administrator. Should an administrator be appointed or not appointed, the court should have said, I feel an administrator should not be appointed. I considered my prayer. Court does not consider the prayer, they only consider B and dismiss both. Please see whether anywhere in this entire order of the learned single judge, there's even a discussion about whether or not to appoint an administrator. There is no discussion. He goes only on the basis of prayer B. Prayer A is not considered even to say, I should not appoint an administrator.
Yes.
He does not consider prayer A at all. This is my first answer.
Don't worry, your one after the other applications, which are still pending.
Yes.
You will again rake up this issue.
Yes.
Because now,
my lord, I have applications for injunction.
Mr. Sundaram, please see your serial number 3 application.
My lord, prayer.
See the prayer in your application number 3, IA 36653. Appointment.
This is the instant one.
On Bina Modi.
This is this.
Behalf of the trust.
This is subject matter of the SLP. Only 3 is subject matter of the SLP. 3 is subject matter of the SLP. 1, 2, 4, and 5 are the other IAs.
Yes.
And my lord, for all those IAs, this conclusion here, prima facie, about interpreting of 2 clauses of the trust deed will necessarily be followed for all the other IAs. My lord,
When previously we see no reason to interfere with the impugned orders passed by one single judge or the division bench of the High Court. All that we wish to observe is that IA number 31728/2024 moved by the petitioner in the pending civil suit is in the civil suit is still pending consideration. The petitioner shall be at liberty to pursue that application or subsequent applications that are stated to have been moved by him in the civil suit. It goes without saying that all such applications shall be considered by the High Court
without being influenced by this order, my lord.
How can you say that? How can you say that, Malad? Without being
influenced by the observations made in the impugned order.
I only wanted to say one thing. He has gone on and on, my lord, on the administrator not being considered by the division bench. Would your lordship do me the favor of just one line at page 854? Just see one line.
We are not granting anything to it.
Just see, my lord, it will be important. 854.
Yes.
I will not utter a word after that.
Yes.
854.
The appeal doesn't lie, Malad.
There is no appeal. Just see, my lord, the prayer in the appeal. He is going on arguing he has a statutory right. 854, my lord, you also get the prayers in the appeal. My lord, the Chief Justice said. 854.
Yes.
854. My lord may see. Pass an order allowing the appeal, setting aside the order. So and so, to the extent of the findings recorded on the interpretation of the deed and the evidence recorded for determining money. Is this an appeal, my lord?
Appeal doesn't
Against
lie,
an
my lord.
administrator's order?
Doesn't lie.
Appeal doesn't lie. Against a finding, my lord, in a dismissal. What is he doing?
Well, the appeal doesn't lie, Malad.
And he's now filed an SLP.
And you know, of the administrator, it was rejected. He's not filed an appeal against that.
Not fair to blame the High Court if this is the nature of your appeal. The High Court should have rejected it with one line. Then you can't challenge the finding, my lord, when I is dismissed.
So right. Long live the litigants who can afford.
Your lordship,
call it
in
an
accordance
epilogue.
with law. Your lordship may
call it an
uninfluenced-
epilogue.
Malad, your lordships may add, Malad, in accordance with law, Malad, that your lordships may add in the order.
Yes,
Your-
yes, sir.
If
Yes,
the High
but-
Court will decide in accordance with law, Malad,
Decided by the High Court.
in accordance with law, uninfluenced,
Influenced by the observations made in the impugned orders and in accordance with law.
deeply obliged.
My lords, please. Lordships, please.
Great.
I'm going there.
May it please, Lord. Malad,
Dispute amicably.
Malad, we took a cue from the court's observation. Malad, I persuaded my clients. They sat down, compromised the matter, all payments made, Malad, and FAR becomes infructuous. There's a compromise deed we have put on record. So I'm only saying one thing. Now, they have said an affidavit that they will withdraw the SLP and participate in quashing of the FIR. So the matter is being prolonged for so long. They have already been inside for about 2.5 months, and they filed for cancellation. Your Lordship, if my friend agrees, Malad can quash the FIR right now. And instead of the whole process going again to the High Court, then trial court and the whole thing. But things have become
FIR by whom?
by my learned friend, saying that during the pendency of the company being insolvency, you had your anticipatory bail, which was granted to you. You paid only a sum of rupees 50 lakhs, then 1 crore was paid during the High Court. Anticipate. Malad, matter reached the Supreme Court 4 times.
No, can you then place on record your joint request with one?
Yes, Malad, that's listed on record, Malad. That is with my application. Page 7 is the compromise deed. Page 7 is the compromise deed and the relevant paragraph in the for the purpose of
You have received your payment or you have received tax only?
all, Malad, I made sure every payment made. Paragraph 4, he says that he will, Malad, if you allow me, says parties have resolved disputes voluntarily, amicably, without any pressure or coercion. Complainant confirms the entire dispute relating to the aforesaid commercial transactions have been fully settled, and now nothing remains due to the complainant in relation to the transaction. Parties now wish to, so the FIR and related proceeding can be quashed. It's his own affidavit, Malad, and in the compromise deed.
All right.
4 times he
Right on. say Messrs. Say leave granted. Then say Messrs. KTC Foods Private Limited. In which respondents number 2 and 3 were directors at the relevant time. Entered into a business transaction with the petitioner's proprietorship firm known as Messrs. Bhargavas and Company. The petitioner's firm is working as a commission agent in the grain market at Jing. The firm is said to have supplied paddy to Messrs. KTC Foods Private Limited, but the value thereof, the tune of rupees 4 points, was not paid. A settlement was arrived at where respondent number 2 and 3 agreed to pay a sum of 3.65 crores to the appellant. They paid a sum of 50 lakh on 14th February 2018, but thereafter failed to honor the settlement. As for meanwhile, the appellant lodged FIR number 866 dated 6th October 2017 under sections 406, 420, 506 IPC at police station city Jing district against respondent 2 and 3 for duping him in the name of settlement. The duping the appellant, the above stated settlement took place in the proceedings initiated by respondent number 2 and 3 for grant of anticipatory bail.
Yes, ma'am.
In that FIR. It may be noticed that anticipatory bail was granted to respondent number 2 and 3 subject to honoring the settlement. So it is however not necessary to refer the facts in detail. Except to say that 841 of 2023 set aside the order of pre-arrest bail passed by the High Court in favor of respondent number 2 and 3. On the premise that such discretionary relief was granted subject to their honoring the settlement. And since respondent number 2 and 3 failed to make payment as per that settlement, the order granting pre-arrest bail could not sustain. That's paragraph. Thereafter, respondent 2 and 3 were arrested on 25th September 2023. But soon thereafter, they were released on bail by the additional sessions Judge Jing on 6/11/2023. The appellant complainant challenged that order before the High Court, but his petition was dismissed. But his petition for cancellation of bail has been dismissed by the High Court by the impugned. Next paragraph. On the previous date of hearing, counsel and senior counsel for the parties were advised to explore settlement the chances of settlement as the entire, as the criminal proceedings, as undoubtedly the criminal proceedings have emanated out of a civil transaction, a business transaction between them. Next paragraph. So respondent 2 and 3 have now moved IA number 3 to 1079 of 2025. Inter alia, placing on record a fresh compromise deed dated 8th December 2025, in terms whereof the dispute has been finally settled between them. The appellant has also executed the copy of the compromise deed duly signed by the parties and the witnesses has also been placed on record, along with the affidavits of the parties, including that of the appellant, in support of the settlement deed. Next paragraph. Consult the appellant, on instructions, specifically informs that the due payment has already been received by the appellant and that no claim now survives. Next paragraph. It is in this backdrop that senior counsel, counsel for the parties seek the invocation of powers of this court under Article 142 of the Constitution and annul the criminal proceedings in view of the settlement and the fact that in view of the fact that as per the settlement, the due amount has already been paid and the very basis of the FIR has thus erased. Next paragraph. We have considered the submission. It seems to us that on a provision of the contents of FIR number 866 dated 6/10/2017, it is explicit that non-payment of the balance agreed amount in terms of the business transaction, as per the business transaction, is the solitary foundation of the FIR. This fact has been repeatedly noticed even by the High Court in multiple rounds of litigation between the parties. Have been noticed by the High Court and this court in the multiple rounds of litigation between the parties. Next paragraph. Since the better sense has prevailed upon respondent 2 and 3, and now they have made the due payment to the appellant, and the claims have been amicably settled, and the dispute has been amicably settled, it seems to us that no useful purpose will be served by continuing with the criminal proceedings. So consequently, we deem it we find it a fit case to invoke our powers under Article 142 of the Constitution and quash FIR number 866 dated 6/10/2017 under section so and so registered at police station in city, police station city Jean, and all the proceedings arising therefrom. All the proceedings arising therefrom. Next paragraph. Ordered accordingly. Next paragraph. It is our clarified that this order shall have no bearing on the merits of any other proceedings pending against respondent 2 and 3 or their company. That because NCLT or whatever.
That those proceedings are all culminated. There's a resolution plan. Everything is over. Only this remained pending, Manoj.
On any other proceedings pending against respondent 2 and 3, their family or the company.
Extremely grateful, Manoj. But sometimes just one word is good enough for the client to understand. He did understand. And rightly so.
Sometimes it works well.
It works well, Manoj. Outside only I told him, I said, I think we should go to Gene straight away. He went, my lord. Grateful, my lord.
Thank you.
This is, my lord, policeman coming from 300 kilometers abducting, wrongfully confining, ransom of, my lord, some bitcoins and 50 crores, my lord. Please see page 14, my lord. The court records that there is a case,
The
there
fact
is an
is that
evidence.
these lower rank police officials, they were compelled or they were forced by their seniors, superiors. They have very candidly admitted this fact.
My lord, please see that the court, High Court records that there was a complaint and there was an investigation which was going on. They accompanied for that investigation. My lord, there was no complaint and they were aware, and subsequently
Constitutional court should
my lord, the
interfere
subsequent
in the
conduct.
order of granting liberty, even if it is order is erroneous.
My lord, please see.
Assuming the order is erroneous, even then why should we interfere?
The only thing is, please see, my lord, the evidence is otherwise. They have
Appeal or anything.
the only thing is, please see, my lord, it is the evidence is otherwise. The evidence records, please see, I'll just immediately point out to my lords that how they were involved. Please have a look at page 380, my lord. There is a finding, my lord.
There is bound to be some evidence, that's why they have been convicted. So that evidence you need not to read before
But
us.
in any case, my lord, if they are accompanying subsequently, only one thing, my lords may kindly, my lord, have a look, that it was, my lord, the logbooks were forced. Thereafter, my lord, there is an application which was made backdated on 20, the incident is of 11th of February. On 23rd of February, they have made a backdated application of 9th of February.
The petitioner also can't be a clean person. The kind of Bitcoin business, this and that, all of you are indulging in this. On bail.
My lord, that bail is also pending, my lord. That is coming up, my lord, perhaps in the next week, my lord. My lord, please have a look. Please have a look at page 380, my lord. They were very much there. They were in assault. They were in abduction. They were in wrongful confinement. They were in ransom. Now please see 380.
That's
The
why they
High
are
Court
convicted.
records.
That's why they are convicted.
My lord, the High Court records, and 3 months they are out and they are all reinstated in job, my lord. My lord, please see 380. My lords may see. Kindly have a look at 380. Please see 380, my lord. There is a specific role. The conviction, my lord, that's my point. That conviction is not stayed.
For that, whether you or some public spirited person, merely because sentence has been suspended and they have been released on bail, they are not entitled to reinstatement. Once they are convicted for an offense involving moral turpitude, and undoubtedly it's a case of moral turpitude. So anybody can challenge their reinstatement.
If at all, my lord, the High Court records that they were simply following the dictates of, my lord, the seniors. Now, therefore, please see page 52, my lord. There is a direct judgment on this of this honorable court, my lord, and at, my lord, at 58. Kindly have a look once, my lord. If, my lord, supposing a subordinate is following the commands, and that to an illegal command of his superior, ultimately that will result, he has to face the music. Within 3 months, they are out.
Sir, that you are right, that may not be a parameter of assessing culpability, but will definitely be a parameter of assessing sentence. So in this view, if there is a suspension of these foot soldiers, why should we interfere?
The only thing is, therefore, I am just pointing out to my lords that they were very much there. The only thing is that the inspector's application, my lord, the police inspector application, the High Court didn't intervene, my lord, in the police inspector's application. Now the 3 months, my lord, 3 months, life.
Life.
364A life and 3 months they are out. Now please have a look. I'm just pointing out the
Also has gone on.
Milord, their role is, Milord, kindly have a look. 380, my lord, may see their role, Milord.
We have heard and senior counsel for the petitioner. In the peculiar factual circumstances of this case where the High Court, in exercise of its discretionary jurisdiction, has suspended the sentence awarded to the respondents, we are not inclined to interfere with the impugned order.
Only thing is, Milord, this order may not benefit, Milord.
To pursue his prayer for early adjudication of the appeal, subject to the other prioritizing matters.
Milord, this order may not be a precedent. This order, they are going to take the benefit, all the accused, Milord, right from top to bottom.
We have said in the peculiar factual circumstances.
My lord may say that.
We have said so.
Very well. Very well. Great.
There you may be right. The senior police officer, they may not be entitled to him.
The senior police officers, the SP is convicted, the inspector is convicted, one MLA is convicted.
That's why we are indicating that constable may be entitled to, but the superintendent of police may not be this kind of thing.
So therefore I am saying, my lords may say.
We have said so. We have said so. Peculiar factual.
My lords may clarify that this may not.
We can't advance in pass an order against them.
Very well.
You will remind us on if they do it.
Please, grateful man.
The technical member retired on October 24. The chairman retired in January 25. The last judicial member in November, and no action.
High Court is now next week.
Well, High Court is just adjourning, and the fact of the matter is we sought some interim arrangement. Lordship have been repeatedly saying that at least the one who is there, let him.
Please don't ask Supreme Court to interfere. It's too much.
Well, I quite see, well, that's the thing. But Lordship may, if an interim arrangement,
our hands are full.
Interim arrangement.
Our hands are full, dockets are overflowing.
I quite see, Mullah. Everywhere the dockets are overflowing, but some interim arrangement, otherwise the dockets will overflow more. Because if the fact-finding appellate authority is not available.
I understand your predicament that you can't be there to assist the High Court. But someone who is
Lordship may at least some Lordship have repeatedly passed that let the last person continue till they make it. It's been now 1.5.
Because it is coming on 17, therefore it may not be. But we will indicate something that
Please,
the fact that
let the High Court make some interim arrangement. That's all what we're praying.
High Court is seized of the matter, and the case is now coming for hearing on 17th December 2025. We are not inclined to entertain the special petition at this stage. All that we wish to observe is that the petitioner shall be at liberty, to seek some interim ad hoc arrangement for the functionality of the appellate tribunal, and such a request shall be sympathetically considered by the High Court.
Deeply obliged.
That will take care of you.
Because otherwise the dockets will overflow over here, High Court again.
Well, this was disposed of yesterday. May I just pass on that order, my lord? Unfortunately, second innings is not possible, my lord. May I just pass on that order, my lord, so that.
Same.
Actually, we are better off than what we were in the High Court, my lord. We are a little better off.
Yes, Mr. Nauri.
On the last occasion.
Now he is in jail, so he has given the list of properties.
On the last occasion,
And he has gone back.
he has surrendered.
On 9th, he has surrendered.
He has surrendered on 9th. But there are, please have a look at the prayers in the application now. Of the application.
Now, what survived in the main case is your prayer for bail.
No, my lord, insofar as prayers with respect to sale of properties is concerned, my lord, I must, my lord, frankly tell my lords, there are some factually incorrect statements in the application. So, my lord, those prayers, my lord, I will not be pressing now, and my lord, I will take out appropriate application. Insofar as regular bail is concerned, I have something to say. What happened was, my lord, after the writ petition was disposed of, my lord, I made an application for exemption from appearance. In that exemption from appearance, my lord, that I was not present, my advocate was present. Application was rejected and therefore the non-bailable warrant was issued. That was on 17th of August.
Mr. Davre, we are, of course, we will hear the entire history. But our main and the solitary concern and consideration is
sale of property and recovery of my lord monies for the purpose of
pay to your investors, your home buyers, or whosoever they are.
Yes, my lord.
They are running from pillar to post. They need to be paid.
Yes, my lord. That, my lord, that's my concern also. Lord, your lordship may just consider, let me just, I'll take just 1 minute. So on 17th of August, Lord, would my lords have a look at, my lord, this compilation. Perhaps, my lord, it will, Court Master. Lord, the 17th of August, Lord, my application for exemption was before the court. Your lordship, today, honorable court was called out. The public prosecutor not present, accused not present, advocate for accused number 1, Shri Kelkar, that is me, present. The learned court passed order exhibit 1 in MDW issued against the accused. The application by the accused seeking exemption from presence before the court and to mark his presence through advocate, my lord, that was rejected. Since, my lord, I was not present, this non-bailable warrant was issued.
With an NBW, how can you ask for exemption?
So, no, that was filed on that day, rejected and NBW issued. No, lord, no problem. What happens is this order was communicated to your lordships by way of report. That your lordships will find next page. Otherwise, my lord, I was on bail and my lord, your lordships had approved that while disposing of the writ petition. This was communicated to your lordships, my lord, and office report is, my lord, submitted next page. Your lordships will find that. Where, my lord, it is quoted that NBW is issued, etc., because I did not remain present. On the basis of this, my lord, your lordships were supposed to pass an order. In the meanwhile, my lord, actually I was, my lord, that non-bailable warrant issued was cancelled. Last page of this compilation. Please have a look at that. Today the matter is taken on board to comply with writ issued so and so. The learned court has passed order exhibit to issue a non-bailable warrant through district magistrate to accused Pradeep, that is me. Similarly, non-bailable warrants be issued against so and so. Production be issued so and so. For issuing non-bailable warrants so and so. For issuing so and so. And my lord, please have a look at, my lord, the order which is passed. In the IA, my lord, I have filed that order. Your lordships will find that at page 22.
Now, what is the argument based on that?
So, my lord, in the meanwhile, that non-bailable warrant was withdrawn. I appeared before the court, but because of the office report before which was sent to your lordships felt that, my lord, I am avoiding presenting before the court, and therefore, my lord, your lordships cancelled the bail. This is the background in which that order came to be passed. I must also confess one thing, Lord, since non-bailable, your lordships cancelled the bail granted to me. In this background, Lord, he was away, absconding, Lord, for some time. Ultimately, Lord, he was arrested in August. Lord, the whole idea was to secure his presence, he cooperates with the court, and Lord, for that purpose.
How can that idea be there, Mr. Navri, when he has been absconding and he is evading?
Lord, what happens is, Lord,
January 25, para 3.
Would my lord have a look at, my lord, the order passed on 4th of January, which is part of the IA, my lord. Page 32.
Mr. Navi, the issue was like this, that there were earlier orders asking you to furnish those assets
Yes.
Can be disposed of for the purpose of creating a corpus. And on that undertaking, bail has been granted. So on 2/1/2025, because you did not comply with that requirement, bail was cancelled. And then
No, my lord, bail was not cancelled because of that. My lord, bail was cancelled.
paragraph 3 and 4.
My lord, yes, my lord, at that time, my lord, he was away. My lord, he was not able to communicate. My lord, your lordship's, my lord, impression that, my lord, on that front, with respect to property is not cooperating. There was no material. The only material was the office report, which was on the basis of
First
issuance
of
of
all,
non-bailable.
give the list of all your properties, assets having clean title, which can be auctioned, and some payment to these poor investors can be made, those who are running from pillar to post for last several years, and their money you are enjoying like anything.
Lord, my instructions, my understanding is, my lord, insofar as furnishing of the list of properties, etc. is concerned, that stage was over when your lordship disposed of the petition. It is for the state. Please have a look at the order which was passed in the writ petition. The state will now auction the property. My lord, please see the order which was passed at the time of disposal of the writ petition. The stage of furnishing the list of property, etc. was not gone through during the writ petition. Your lordships have passed an order in the writ petition saying that now the state will take steps for auctioning the property. So, my lord, the list, etc. was before the court, before the state government.
Therefore, file an application, we can constitute a high power committee that will do it.
Lord, your lordship may do that, or my lord, let state, I have no difficulty about that, but will not serve purpose either way. In fact, you have to cooperate.
You want the state to dig out, find out first and locate your property.
Sorry, my lord.
And then you want the state first to undertake an exercise of identifying the properties owned by you, your company or family, and their application of auction will come.
Lord, I'm sorry, my lord. That exercise was done by before your lordships. My lord, please see the record of the writ petition. Therefore, your lordships, while disposing of the writ petition.
Even according to you, so many properties, you are saying already there is a charge of the bank, some loan taken, some property mortgage, some here and there. How do we know how those properties can be auctioned?
My lord, may I just put it this way? My lord, if he remains inside, he will not be able to do anything. My lord, for the state to have some cooperation, my lord.
That is the reason we initially allowed him to continue on bail. And he kept on, you see, this is a case, a typical case where he kept on duping the court. Initially, they said, along with him, three petitioners, that we are coming with a proposal. We will give a plan how to make the payment. We kept on adjourning, granted them protection. Then 2 and 3 came before us saying, P1 is not cooperating, he is not giving details of the property, he is not cooperating, but we are helpless.
No, my lord, I'm sorry, my lord, they have not stated this.
Please, my problem is that I never forget the facts once I go through it.
Very well, may I suggest?
I will point out that.
May I suggest one thing? Your lordship may have it, my lord, after vacation. My lord, I will produce all records showing that, my lord, insofar as the.
No, you don't do anything. You need to do only one exercise. Give us the list of your clean title of yours, private, personal, company. And we constitute a high power committee. You can make a prayer to that effect. If you don't have trust in the state, we'll take the state officers also a member. We'll direct some former judge to supervise it. And your assets will.
I will, my lord, in that case, I will request one thing. My lord, I will file fresh application with all necessary details with also a prayer for bail. This application, my lord, as I said, there is some, my lord, factually incorrect
information. Also for the petition state that the pending application has some factual errors. Factual errors, therefore he does not press that application. He seeks and permitted to file a fresh application along with correct particulars. We are saying that you don't want to press the earlier application and you want to move a fresh application.
Please, my lord.
We are permitting it.
Please, my lord, I'm so obliged.
On the lighter side, your lordship said you never forget the facts when you read them. On our side, we have to forget the facts because we have to argue the next case. We have no choice but to forget.
The moment I see the paper book and my notes, then I recollect normally. Because what I do is, I have a...
No, that we have seen, in court. We've seen that.
I have bad habit of this. So the moment I see that reminds everything.
Lord, can this be kept, my lord, on some day, my lord? We have prepared something. We'll share it.
That lady has been brought back.
Yes, yes, my lord. She's
Is that matter, no?
yes, yes, the same matter.
And is she getting some proper treatment and look?
Yes, yes. There is no.
She's in her father's house and they are monitoring her.
Any financial assistance she requires, Mr. Hegde, anything you.
She was working as a maid in Delhi.
not
So
going
that,
to,
that,
but
that's
if
her
it is required,
financial-
I don't think.
State government.
the state government will make adequate provisions, and we are grateful for that.
We'll try.
Accessible, you issue instruction to your administrations.
The government, central government also, on humanitarian grounds, I.
Purely on humanitarian.
We will also provide whatever.
The legal issue we are not commenting today. The first consideration was only to ensure that she is brought back.
She is brought back
Medical
immediately
aid.
in 48 hours.
Medical aid because she is in family way. The rest of the legal nitty-gritties will come later on.
Yes, sir.
First, we were only concerned about that part.
Only one thing
There
I
was an emergency situation because she was so visibly.
And the other child, 8 years old, has also.
Yes, he's come back. Now there is the other lady in the other petition. She is a lady with 2 children, and
have something to say on that, my lord. We have the.
What I'm appealing to the Solicitor General's humanitarian approach in this matter. I can provide documents about them also. Let him, about each of these 4. Let him take a look, prima facie, without any judicial this one. And the same thing.
What about the husband? Only.
All 4. All 4. There are 4 people in this. Let them.
That's the second one. I'm talking about the first.
Both.
Lord, I'm sorry. Husband should be brought back. What is the point of keeping them?
Things can happen in Bangladesh. You don't know what. Why there is.
Sorry, but
Okay. tell you, it would be looked at in right earnest with the spirit in which it is given. Let this not be a subject matter of tweets or articles, but I want to share something.
My lords.
Not you.
Meanwhile, Mr. Hegde and
The girl, unfortunately, it appears become
Yes,
part of some ecosystem.
file your counter affidavit.
Unfortunate.
Whatever documents you want to rely
We'll place
upon, you
them on.
bring them on record, because right now we don't have, we were only on the humanitarian ground.
That will.
Once the documents come, then we will consider the modalities,
Obliged.
how in a time-bound manner,
Yes.
in the prescribed authority, the competent authority should determine the status of
Yeah.
the person, and then all consequential actions coupled with whatever interim arrangement that may or may not be required, that we'll consider it. Right?
Please, my lord.
You file at the earliest in 2 weeks' time.
In this side of the vacation, that was what I was requesting, because we can do it. We are on Friday today. We'll file by Monday.
We need time for verification.
No, we'll give you the documents today.
Verification.
Our
Because there are certain
problem is
documents which are found
the
to-
parted matters.
Last week, not miscellaneous, my lord.
Only 1 week, and we are very keen to conclude the.
Yes, the other.
I can't say anything about that part of it, but if your lordships could have a hearing on Thursday afternoon or Friday afternoon, the last day I'll stay back. My
So
late
Friday afternoon, last day, my lord, is generally,
Mr. G. Ramaswamy,
There is
my late senior used to say
there is
that
a
blind man
sanctity
wants an
attached to
eye.
that half day, my lord.
We want, that side of the border is very difficult, my lord, for Indians.
Maybe your interest
No,
also,
don't say
because the
that, don't
state
say
will
that.
also have some time.
Enough is said.
The state
Enough
will
is-
be able to find out some documents, some record. They will also be.
It's
able
been
to
done.
proceed on
It's
it.
been done, already done. We have them.
You-
We have the documents.
But you have not yet filed your counter.
Nobody's
No,
filed.
Nobody's filed, but we have the documents.
No, petitioner should have.
I will file.
I'm just saying, the
You
state
are for
also
the
has the
state, you
documents.
forget that.
So for a change, you are the petitioner here.
No. The original writ petitioner should have.
What is
The state forgets that it is not. an
No, that's
original
not
petition.
true, sir.
They
We
may
have the
support,
documents in
but
any.
not
case.
this open.
If the union does not do an inquiry for 30 days, that's
Yes.
what the High Court has set aside that order.
I will
You
satisfy.
should have
the
done
court.
an inquiry before deporting them. You haven't done it.
May I
that's all.
say something else? Now forgetting this matter,
This side of the vacation, that's all I'm saying.
my lord, can I say something, my lord? I don't wish to escalate this issue. Matter is
not
over on
right.
merits. My lord, there is a concurrent and simultaneous narrative building exercises going on. I'm sure it doesn't affect your lordships. But there are certain tabloids which are normally known and used as narrative building exercise. Unfortunately today, to my amazement and shock, I read a front page story in a reputed and dependable newspaper like Times of India. Must have escaped the editorial attention. My lord, it is for.
We
Your lordship
normally are.
cannot comment. I will not, my lord, request anything.
Normally we don't get time to read newspapers because.
Yes, my lord. It is for the newspaper to decide.
My brother says rightly so that we get supplementary.
Your lordship are right. That's.
Justice Barucha, you tell us.
Let's not go to history. Yeah, I am on the present day.
Everything is history. Everything that we do is.
I know even if your lordship reads, it doesn't affect. But let it remain in the domain of those tabloids.
Oh, there is
Times
a
of India.
publication about this case.
Not something which can influence, attempted to influence.
I haven't read it.
Not,
We haven't read it.
but Times of India, Indian Express, Hindustan Times cannot be
How can we?
reduced to the level of tabloids. You plant stories. It's for the newspaper to decide.
2-3 things only we can say. One, a very sincere advice that never write anything on a matter which is sub judice.
Yes.
Let why one should create an impression. Second, we can assure you from the court side, we don't accept pleadings which are outside the paper book.
I'm
There are claims filed, there are counter claims filed, we simply ignore them. That is yesterday probably in one of the matter, I and my brother, we both observed. That doesn't affect our working.
That
We
was
should
the
also think of this.
thing to do, my lord, for especially the people who are appearing.
Since-
Very cheap thing to do, apart from being.
Since the Solicitor General is very fond of Urdu poetry, my lords, 2 lines. नहीं है किताब बे जमाना गम के काबिल, तेरा जवाब यही है तो मुस्कुराए जा. So it's like that.
Lord, that's the difficulty. We have reached this
Anyway,
stage.
let's not sort of.
We do not take
Court of
things seriously. We just laugh it out. And then Supreme Court of India is mocked with showing one copy.
Ideally, in a sub
That's
judice
the
matter, ideally about a sub judice matter, there should not be any running commentary. There should not be.
Absolutely, Manoj.
Once the judgment is passed,
You can have criticism of the view taken.
any healthy criticism is always most welcome. That
Yes,
is
yes.
always enlightening. That makes her more and more wiser, and maybe that if the court commits any error, it gives an opportunity
That's
to
how
rectify.
jurisprudence also grow, Manoj. There is no difficulty. But this is a trend, Manoj. This is a pattern. This is not.
You are saying the Times of India has published.
Yes, Manoj.
Today.
Therefore, I don't wish my faith to be shaken from newspapers like Times of India, Indian Express, etc. It's for that editorial thing to take a
There are
call.
so many narratives and counter narratives, Manoj, that are with in newspapers, Manoj. How do we?
Not only newspapers, there are other media.
I agree with you. There are narratives and counter narratives, but what is to be done? Let's concentrate on what's in court.
Just ignore them. That's all.
Let's concentrate on what's in
तेरा
court.
जवाब
Yes,
यही
yes,
है
sir.
तो मुस्कुराए जा. That's it.
No, Manoj, we cannot laugh
That's-
it out.
you
We
can't-
have to take it.
Mr. Solicitor, our request to you is, we are completely immune from.
I'm fully confident.
Of publicity or pseudo publicity endeavored on a news.
Your lordships would not be affected even if your lordship read.
Request,
I was concerned about
I will-
my faith in the news.
request you, sir.
I will show my learned friend, Manoj.
Narratives should not affect lives of individuals.
That's right.
Absolutely.
Yes, yes, Manoj, they cannot.
Lives, their
Manoj,
human
unfortunately,
requirements.
the lady
not-
seems
we
to
can
have become a part of
And this should
Not
not
some
become a
ecosystem.
discourse.
A
This should
very
also not
broad
be part of a
thing.
discourse.
We
in
can
this
only appeal and we can only advise. Reporting a matter, there is nothing wrong. That a matter came up for hearing or these are the proceedings which took place. Nothing wrong in that. Or even reporting that a matter is coming where issue is involved is this much. That is also there is a, because you are telling, you are bringing to the public domain that there is a matter where this question is involved and is coming for hearing. So far as that you know. But if you thrust upon your opinion
Yes.
on the court,
Try to infuse kind of an emotive
preemptory
thing,
language.
Manoj, which is not factually true. And Manoj, we have in Times of India, Manoj, the legal journalists, they're so responsible. They write, Manoj, so responsibly that it is enlightening.
The author and
This is-
publisher both need to be responsible. The author and publisher both need to be.
Manoj, maybe must have escaped that.
Globally, even in the US Supreme Court in England also, when the matters are going on, there are commentators who comment on what's happening.
We are not in England or America, fortunately.
Of course, you're not.
We have
in
our
England.
own
I am
system.
glad you are not in England, but I'm just saying, that this is now part of global discourse. Because if there is an immigration order by the president,
think they
that
are
is the subject
calculating.
matter
I
of a
don't
lot
think
of
they are
debate as
calculating.
to why it should be passed, not be passed, emergency order, tariffs. These are all matters of public debate, even though, presidents have passed
not
these orders.
calculated
It's not
to
as if, it's not as
influence
if
the
this is
proceedings of
something
the
that is
party.
sacrilege. As long as you don't attribute a motive, it's not sacrilege. Because people don't have information. One kind of information goes to the public, the other doesn't
The
go.
problem is, Mr. Sibal, when the half-baked truth, distorted facts, ill-informed people, they start writing, they start commenting, then it sometimes creates a different kind of public,
Well, this happens to us personally every day. This happens to us personally every
We
day.
have
Has anybody
social
objected?
reformers.
Has my learned friend ever objected to the kind of things that are said about us every day?
Manoj, if I can give an instance.
Leave
Yes,
it,
yeah,
leave it. Let's move forward.
An instance from the Calcutta High Court, since my Lord Justice Bagchi was there. My Lords, there was a excise matter, classification between skin and hide. So the judge asked, what's the difference? So the senior advocate replied, when I was young, I had skin. Now I have hide. The Solicitor General, my Lords, as the government, my Lords, we all have thick skins. These things happen. The case has to be argued on its own merit.
doesn't matter.
No problem. This side of the vacation, that's all I'm saying.
We take up it on the opening itself, Mr. Hegde.
First week of reopening.
On 6th, we will take up.
6th. Obliged.
Because otherwise,
Fair enough, fair enough.
On-
All the documents.
We'll put all the documents,
Lord,
we'll put an explainer of the documents also.
and meanwhile, wherever Mr.
There is a contempt file, my Lord. He may agree not to proceed. My Lord.
that they will not.
It's listed today again, my Lord. That's the problem.
Which one?
Contempt. No contempt. That. Of course not.
No, they will not pursue the contempt. And wherever you feel that on humanitarian considerations, someone can be considered.
Certainly, there is no doubt about it, my lord. Your lordships can rest assured.
Without prejudice to legal arguments.
Lives and families could not be.
I bow down, my lord. A single word uttered by me here, my lord, would be again a subject matter of some. We have a breed of social reformers. My lord, they will come out. Obliged to lordships.
No.
Obliged.
Thank you.
I'm grateful, my lords. Grateful.
May I please, my lords? Lord, the government is, even before the Land Acquisition Act, trying to take away the land. Thereafter,
Doesn't have some discussion. We appreciate your predicament, but let us, only last chance has been given. And you will, in a way, indirectly you will be compensated. Because postponement means the cut-off date for determination of compensation also gets postponed. So instead of the rate which was in 25 beginning or 24, you now will be entitled to that annual.
I may be permitted to approach the appropriate authority or challenge the land acquisition proceedings, my lords. Because initially, my lords, what they did is that without even any proceedings, they took up the land. Then I approached writ petition. Writ petition granted 4 months time, let them finish it, or you take back the land. I took back the land. Again, my lords, they took back the land without even completing the land acquisition proceedings, no compensation paid, no damages paid. 3 years, my lord. 3 years they've been pending it, my lords.
So we have heard on counsel for the petitioner at a considerable length. Since the High Court has extended period for the authorities to complete the acquisition process in a time-bound manner, we are not inclined to interfere at this stage. So, however, if the authorities fail to acquire the land in accordance with law and or pay compensation to the petitioner strictly as per the current law, the petitioner shall be at liberty to question the very process of acquisition afresh before the High Court. I think that will take care. That order itself will now help you.
Grateful. Keep your place.
Really good.
Pass them over the bank to go for mediation.
My lord.
The bank is ready to mediate, my lords. I just have a small request subject to my lord's pleasure. Both the parties are in Chandigarh and Mohali. If we can ask them, because the record, voluminous record.
No, let it be in the mediation center at High Court.
Punjab, High Court. Great. My lords will be giving a date.
Mr. Sudhir Walia, learned counsel for the petition bank, on instruction state that the bank is also willing to go for mediation to explore amicable settlement between the parties. So since the parties are located at Chandigarh / Mohali, the matter is referred to the mediation center attached to the Punjab and Haryana High Court at Chandigarh. We request the mediation center to entrust the matter to a senior mediator. The parties are directed to appear on so and so date. That's also time. Next week of the time.
The date we get from order.
No, we'll notify the court.
Grateful. Obliged.
Maybe. Lord, in item 10, your lordship in the other matter had noted, Lord, now HPSC has auctioned, Lord, some of the properties and about 200 crores, Lord, they have received.
200 plus crore they have.
200 plus crores, Lord, they have, Lord, now.
And they are in the process of, they were saying on that day 100 crore something.
Lord, in your lordship's order of 25, Lord, 24th of March 25.
This matter is pertaining to those consolidation of FIR.
Yes, consolidation.
So that interim stay will continue.
Yes, that interim provision, Lord.
They post the matter in March and interim direction to continue.
Lordship, please. Lordship may indicate that it be continued till further orders, so that because
the interim direction will continue till further. I think this order is always there till further orders.
Great.
It's a caste validity matters.
Item 11. Your Lordship, I had moved a letter for adjournment. The learned senior counsel appearing in the first matter.
No adjournment, except these are all covered matters. Mr. Diwan, what is the position?
No, but I am.
Some of the matters.
Yes, so I am in that subcategory of mana. So that,
mana is not covered.
Yeah, so I'll just explain to from my perspective. We had on the last occasion supplied one list for tagging. In fact, in my case, your Lordship will find that. But then the intervener in that case gave some 2-3 other cases, and so the mana group has come into this Thakur group.
There are 4 matters.
Yeah.
Where this issue of mana.
Yeah.
Or in one case, money.
Yes.
In fact, there are 3 expressions used: MANI,
yeah.
MANE, yeah. and MANA.
Yeah. And there's also Mane Kumbi.
Yes.
Bhor money.
So these items, subject to what you say, we can detag.
I would request that.
And list on a different date.
Yes, I think so. That's my request.
So please correct us if there is a mistake. Item number 11, 11.16, 11.17.53.
Yes. I think there's also probably 11.52. But I'll check that up.
Just check. If that is also there, then we will add it.
But 11.16, 11.17, 11.53. Yes.
11.53 also is mana. 11.17 has to be there. Concerning mana.
In Thakur?
Item?
No.
Yes,
1653. 53 there. 53 there. So these are the matters where this mana, mane or money.
Yes. Yes.
That issue is there.
That variation,
So
yes.
that we will take
I think so. It can be.
At earliest, my lord. Only request is at earliest. Only request is as earliest subject to your lordship.
Just a minute. We are coming to the other part. These matters we can take, say, our order to be detached and be listed on any date.
Okay. But so there will be 2 issues. Yeah, okay.
Mr. Diwan, we can take up subject to both sides, either on 27th January or 28th January.
Whatever day.
Whichever.
So 27th January then. It's a non-miscellaneous NMD.
Yes. Better.
The other matters, my lord, there are.
Other matters we are just coming.
27th would be a miscellaneous.
27th.
26th is a holiday.
26th is a holiday.
Then 28th January.
Sir, 28th January.
28th January. 28th January.
Yes.
27th will be miscellaneous day because of 26th January.
Yes.
Being holiday. Now, what about the other matters?
In the other
Our impression is that most of these matters are now covered by a judgment of
Yes, according to us, it is covered by.
I'm in those group of matters, I'm being led by Mr. Sibal. That's not true. My lord, the lead matter arising out of Shilpa Vishnu Thakur, where Mr. Diwan led me, was principally.
One matter we have completely now detached.
Yes. I'm talking about.
We don't want.
I'm only responding to your lordship's query.
To come here.
I'm only responding to your lordship's query.
Okay,
So far as the matter arising out of Shilpa Vishnu Thakur, which is covered by 3 judges judgment, principal issue regarding the affinity to be watered down.
All right, one way out.
Please.
If there is one-to-one, any case-to-case factual issues are required to be gone into. Some principles have been laid down by this court. Now, broadly, the criteria is laid.
Correct, that's right.
What is acceptable, what is admissible, what is not admissible. We can send this case back to High Court.
My lord,
Yes, that's what
This has to be, there has to be some adjudication.
my lord, the similar request was already.
We instead of deciding against you right now,
I don't know why my friend is objecting to
Almost
it.
like
Most
only
of the
request
cases,
is, my lord,
most of the cases, the High Court has not gone into the details.
So
But it has broadly decided it.
Lordship, I'll prepare a chart. Each of the matter was not covered with regard to the affinity. There are 5-6 issues independently in all those groups of matter.
therefore those issues will have to be gone into by the High Court.
Correct.
Yes.
That's what
Issue regarding area restriction, issue regarding your zone of consideration, etc. There are 5-6 issues. And
This is not an adversarial litigation.
Which was
Already decided by this court.
But we just decided, review has been dismissed.
This was not decided. Lordship, kindly have it on Monday. I will prepare a list.
We are not adjourning them.
Well, there was a specific request which was already turned down, similar application.
Let's be fair to both sides.
Honorable High Court can decide if he has got validity. There are such a certain matter.
In the remaining matter, the leave granted. The issue that falls for consideration will be note in the other case.
Respective High Court.
Now, in all these matters, the word Thakur is under consideration.
Yes,
The issue that arises for consideration in these cases is whether the appellants or other similarly placed persons who claim themselves to be scheduled tribes, being in the category of Thakur, whom are entitled to claim the benefit as scheduled tribes. It may be noticed that the High Court had wide influence judgment cancelled their caste certificates. Cancelled the caste certificates of large number of persons on the basis that they did not meet the affinity test for being considered as part of inverted commas Thakur tribe. Next paragraph. It is not in dispute that a two-judge bench of this court, wide 24th March 2023, titled MAH Adivasi Thakur Jamaat Sanrakshan Samiti versus State of Maharashtra and others, Civil Appeal number 22, and another connected matters must have been also reported so and so. Has held as follows, para 36, ABC. Next paragraph. It may be seen that this court has categorically ruled that the scrutiny committee, after holding an inquiry, that only when the scrutiny committee, after holding an inquiry, is not satisfied with the material produced by an applicant claimant, in bracket like the appellants, comma, that the case can be referred to vigilance cell. For doing so, comma, the scrutiny committee is obligated to record brief reasons in support of the conclusion that it was not satisfied with the material produced by an applicant. The occasion for holding a further fact-finding inquiry by the vigilance cell
Is not supposed to.
would arise only when this preliminary test prescribed for the scrutiny committee is successfully met. Next paragraph. In light of this, comma, there can be no other. In light of this, comma, we are satisfied that all these matters require a fresh consideration at the hands of the High Court, especially to find out whether the reports of the scrutiny committee or the consequential further inquiry by the vigilance cell meet with the parameters laid down by this court in this IT decision. Next paragraph. It goes without saying that in that process, the party shall be at liberty to rely upon additional documents if any, and the High Court for that purpose may accord them one opportunity. Next paragraph. Owing to the urgency of the matter, we request the High Court we request the Honorable Chief Justice of the High Court to constitute a special bench where all these matters may be listed, preferably to be taken up on day-to-day basis. Next paragraph. It is clarified that we have not expressed any opinion on merits of the case. Next paragraph. The parties are directed to appear before the High Court on so-and-so date.
Let all contentions be kept open.
Apart,
Paragraph. All the questions of law
please.
are kept open.
Lord, apart from, Lord, she may record.
We may be permitted to file additional documents.
Already said. Already said.
Yeah.
Lord,
Rightful,
one more issue.
So the
Lord,
civil appeal number 2502.
Take the mic and tell what do you want.
Lord, apart from affinity test of Thakur, in those 49 matters, there are 5-6 issues involved that will also be considered by High Court. Because there are area restrictions, there are tampering of the record.
We understand that. Please point out if there are if some of the appellants or other claimants or other applicants are claiming themselves to be scheduled tribe, not as Thakur, but in any other subcategory, their claims too shall be determined by the High Court, applying the same principles as have been laid down by this court in this IT decision.
Exactly.
Only last prayer, my lord.
May I request civil appeal number 2502, which was the lead matter, which was filed by an organization, that did not be sent back.
That is disposed of. My learner
petition stand disposed of in light of the decision of this court.
Yes. In the light of order dated 24th March.
March 20.
Same judgment.
Same judgment.
While issuing notice, last submission, lords. While issuing notice, interim relief was granted to most of the petitioners.
So your achievement
that may be retained. Interim relief, because most of the petitioners were in service.
So
and interim relief was granted by your lordship.
The matter is since there was a status.
Interim relief may be retained, my lords.
Interim orders will continue to operate. Interim direction issued by this court shall continue to operate till the matters are finally decided by the High Court.
My lords, in item 11.13, also the petitioner has already retired in 2023, and he has got all the benefits under the caste that he was claiming to be. So that matter may also not be referred back to High Court because the petitioner has already retired, my lords.
Item
11.13, my lords. Ashok.
No, that's Dinesh.
He is in which category?
Which matter are you talking about? That's my matter. Did I appear in that?
What?
No, the 11.13 is Dinesh Ramesh Thakur, but
I think she's mentioning some incorrect matter.
My lords, Ashok versus Divisional Controller MSRTC.
13, just tell the party's name also.
No, 11.13 is I appear in that matter. She's speaking about some other matter.
My lord, Ashok versus Divisional Controller MSRTC.
Oh, your item is 11.31, not 13.
My lords, I apologize. 3-1.
I apologize. Just listen. Item number 11.31. Leave granted in view of the peculiar facts and circumstances of this case.
There seems to be some confusion. Even in that matter, I appear.
That's my.
So I don't know.
But we are granting benefit to him.
Very well. Very well.
So far as
that should be allowed.
So far as
the peculiar facts and circumstances of the case, namely that the appellant has already retired from service on superannuation, and the caste certificate issued in his favor continue to operate as a result of interim protection granted by this court, he will be deemed to be a scheduled tribe for the purpose of retiral benefits. However, the said certificate shall not be utilized by his children or other family members unless they prove their claims separately before the appropriate form.
There is a
Benefit being granted to him as retired, you can't extend to his family.
so far as validity is to his family
For
also.
this purpose, liberty is granted to the children or other family members of the appellant to approach the High Court.
Item 11.13.
Yes, Mr. Chitle, now what is left?
My lord, so far as 11.13 is concerned. My lord, so far as 11.13 is concerned, my lord, I am appearing for the state. 11.13 is concerned, which your lord.
You are not unnecessarily confused. Why you are, what is the stress you are carrying?
My lord, 3 judges bench of this honorable court in Jagdish
You are appealing for whom, first of
State
all?
of Maharashtra. State of Maharashtra.
So state, why, as a state, you had issued certificate. High Court has cancelled. Why you are now?
I am appearing for the Cascoti committee who has cancelled the certificate as found not belonging to given schedule.
You had cancelled the certificate. You please continue to plead your case.
My lord, that's a different issue.
This court has
They want
taken
a
a view.
different,
If this court has taken a view after hearing you,
no.
we'll have to respect that view.
So far as 11.13 is concerned, I am not on interim relief point.
We have not said even a single word from our side.
Was dismissed. This is again arguing. Even the.
All right, thank you very much. Thank you for cooperation. Thank you.
Grateful.
Thank you.
My lord, that there is some confusion, my lord, because I am the AOR in that matter, my lord. I have no instructions to state like that, my lord. 11.31.
Because
That
the
is Ashok
brother-
Kathe. And
The
there are three
brother has
brothers
been
who are
validated,
all
declared.
it
Family members are declared as scheduled tribe. I don't know.
Madam Akansha Rathore.
My lords, I appear for respondent number 1, MSRTC. I am the employer. He has retired and he has been given all the consequential benefits.
Oh, come on.
No, you are number 1 means the employer.
Please, my lords.
What I have said, she would have said that earlier.
Oh, then we can record, then say like this. Say, in item number 11.31, comma, in all fairness, say leave granted. Then say, in all fairness, learned counsel for respondent number 1 points out that during the pendency of these proceedings, the appellant has retired from service on attaining the age of superannuation. He has been granted retirement benefits also.
Absolutely, my lords.
And all the retirement benefits have been granted to him. Since the in view of these peculiar facts and circumstances, comma, and with a view to close proceedings qua the appellant, comma, we deem it appropriate to invoke our powers under Article 142 of the Constitution and declare that the appellant, in bracket, and not his family members, bracket close, shall be deemed to be a scheduled tribe for the purpose of for all the service benefits. However, he shall not be entitled to the benefit of that certificate post-retirement position. So tomorrow, suppose he wants to contest the election, we will not allow him.
Just tell me, give me a second time.
For any post-retirement position, or his family member, his children or family members shall be at liberty to approach the appropriate form and assert their claim of being scheduled tribe. Such a claim shall be determined by the competent authority / High Court in accordance with the law.
In fact, the 5 members were already declared a scheduled tribe in his family. In his very family, 5 of them already have been declared as scheduled tribe.
They are declared there, we are not touching.
Therefore, my friend is giving a concession. That is actually
because he was their employee. No, they will not.
Similarly, may I just
no, thank you very much. Thank you.
Request then may I say, even so far as the others are concerned, let the High Court itself consider.
However, the claim of the, don't mention the appellant, he will not be entitled to any position, that's all, stop there. However, the claim of the appellant's family members shall be redetermined by the High Court in light of the above mentioned remand order.
In case, their claim is invalidated. Otherwise, they will reopen all who are declared as scheduled tribe.
shall be redetermined by the High Court, that's all.
In case, my lord, it is, in case it is invalidated, in case it is invalidated, someone whose claim is validated, my lord, again the High Court would be.
FCI versus Jagdish Baira, 3 judges bench have already interpreted Maharashtra legislation. Benefit has to be withdrawn merely on invalidation.
Validity of scheduled tribe certificate in this case, the question of law, validity of the scheduled tribe certificate in this case is kept up.
Deeply obliged.
Very
Milord, so, Milord,
not entitled to.
May I make one request, Milord? 11.
Item 11 and item 11.17, Milord.
What is the problem? All of you are starting saying one by one. Please connect them. Yes, Mr. Chitle, what do you want now?
11.16, 11.17, Milord, these are state SLPs. And Milord, here validity has already been granted in the family, Milord. Like 11.17, Milord, his father has already been granted the validity.
So the matter will go back to the High Court.
Milord, the state is
We have segregated. Mana matters are segregated. Mana, Mane, etc. Those 4 matters have been segregated. Those have been detagged.
11.
Yes, there is one Mr. Deshpande.
Your Lordship, I am appearing. Your Lordship, he is requesting for the matter to be second week of February. Those Mana matters which were segregated instead of 28th. Any date in second week of February, Your Lordship.
Mana we have segregated and listed on 28th January.
28th January.
He is requesting for a date in February, Your Lordship.
Now councils have
On 28th, you can make a mention. We'll accommodate you.
Oblige.
Just one request. In 11.
Yes, what else remains? Otherwise, please disappear from the screen. Unless you are creating confusion.
Milord, only one request, Milord, 11.31, which your Lordship disposed of. Instead, your Lordship may have it on Monday. Let me go through it. I think it's the same matter my friend has. Otherwise, Milord, or else send it back, Milord.
Thank you. Long live
Let it go before the High Court, Milord, in the same terms.
All right, thank you very much. Thank you. Item 15.
Who have retired in the meantime, in some employees, like in 11.20, that
11.1 is over now.
No, it's 11.20. She has retired from service during pendency of the SLP and civil appeal, but she has not got pension till date.
That claim you can raise before the High Court.
That is what. I agree. Wait.
I
am so well.
Item 15.
My lord.
The parties of SLP. But you are Lalmani Devi.
No. Anupama Chaube, respondent.
Item 15.
Item 15.
Hridayesh Chaube and Anupam.
That's right. Hridayesh is the husband. That you see the winner is what is her name?
Anupama Tiwari Chaube.
Anupama.
Part payment is received by her.
So this transfer petition has been filed by the husband and his mother and his family members seeking transfer of domestic violence case number 143/DV/2022 titled so and so pending before the Additional Chief Metropolitan Magistrate, 9th Court, Bandra, Mumbai. They sought transfer thereof to the Court of Metropolitan Magistrate, Silda, Kolkata. Next one. The marriage between the petitioner number 1 and the respondent was solemnized on 4th December 2011. A daughter named Shrutika was born from wedlock on 27th February 2014. Please correct wherever there any factual mistake is there. It seems that on account of temperamental differences, the parties could not live together The differences led to registration of FIR number 679/2021 by the respondent wife, as well as the domestic violence case number 143/DV/2022, the transfer whereof has been sold. Next paragraph. When the matter came up for hearing after notice on 19th September 2025, it was informed that the parties have amicably settled, but they were referred to mediation center.
Earlier it was in mediation center. Here, later on it was.
The parties were referred to mediation, and pursuant thereto, they have entered into an amicable settlement, as was reported on their behalf on 19th September 2025. Next paragraph. Thereafter, the parties have filed IA number 283/888 of 2025, invoking powers of this court under Article 142 of the Constitution, read with Section 13, Capital B of the Hindu Marriage Act 1955. Along with the application, settlement deed executed between the parties has also been dated 7th August 2025 has also been appended. So there is application to do. Next paragraph. Now this 1.65 that has been paid?
No, 65 lakh has been paid. 1 crore is to be paid as yet.
We are paying the demand of 1 crore.
As per the settlement deed, petition number 1 has agreed to pay a sum of rupees 1 crore 65 lakh respondent as full and final settlement of all claims of her own and of their daughter. We are informed by counsel for the parties that was paid earlier.
Yes.
And today, a demand draft bearing number so-and-so, dated so-and-so, branch so-and-so, of in the sum of this 1 crore has been handed over to the respondent who is presenting person. Next paragraph. Petition number 1 has already paid 22,70,000 towards maintenance, and this amount has been excluded from the lump sum amount paid earlier or today. From the lump sum amounts of it. Okay? Petition number 1 has also returned the personal belongings of the respondent. Have you got?
Yes.
Respondent. Like personal belongings from articles and other household items. Both the parties have confirmed that nothing further remains to be returned between them in this regard. Next paragraph. Petition number 1 and the respondent are present in court. We have individually ascertained from them and both have acknowledged that they have their marital dispute and have executed the settlement deed dated 7th August 2025. So, in this view of the matter, we find it a fit case to invoke our powers under Article 142 of the Constitution and dispose of these proceedings with the following directions. The marriage between the parties is hereby dissolved by way of a decree of divorce by mutual consent, ordered accordingly. The FIR number 60/2021 and CMM court case number PW/900479/2022. Any other case?
We have indicated all the dispute between the party at page 14, Your Lordship, para 14 of the joint application.
There is a table to that effect.
at para 14.
Then से ये जितने केस है ना बहुत सारे हैं ये जो क्रिमिनल केस है सीरियल नंबर 2, 3, 4 अभी तो ये लिखा all are इनको मेंशन करके are hereby quest the proceeding and all the proceedings arising therefrom are hereby quest. Then next execution petition number criminal receipt application number 134/2024 ये serial number 1 is disposed of as having become infructuous. Then say similarly revision petition REVN 594/2024 serial number 5 is also disposed of as having become infructuous. The next matrimonial suit for divorce bearing number 483/2024 serial number 6 को देख लेना is also disposed of as infructuous in view of the fact that marriage between the parties has been dissolved by a decree of divorce by mutual consent. Para 7 perjury application is also disposed of as infructuous. Next paragraph. If there is any other or civil litigation, complaints, etc. pending between the parties, the same shall be deemed to have been disposed of as infructuous. The interim orders passed in the previous proceedings are also deemed to have been vacated. That's it.
My lord, one more submission.
Vacated. Just a minute. The parties have agreed not to initiate any legal proceedings or complaints against each other henceforth. What about the silver items, etc.?
That is there in the PS Khar Mumbai, that is lying there. So that police station may be directed to enable her to recover it.
The silver items and the watch deposited by the petitioners at police station Khar Mumbai in relation to FIR number 679/2021 is directed to be released to her,
my lord,
to the respondent,
my lord,
immediately. The police authorities shall comply with this order without any delay. Any other thing?
One more humble submission, Your Lordship. Para C of my joint application, we have deposited a sum of rupees 15,000 as a bail bond. 60,000 total. 60,000. Total 60,000. It may kindly be directed to be released, Your Lordship. Para C, page 9 of the joint application.
Paragraph 3 of
Para C.
15,000. 15,000.
15,000 for the food.
The amount of this 15,000 deposited by the petitioners, along with surety furnished by each one of them in connection with FIR number 67/2021 under section 498A 406/34 IPC 506 of IPC and CMM court case number PW वो इधर repeat कर देना 900479/2022 is ordered to be released to them in view of the fact that all these proceedings have been quashed.
One more humble submission, Your Lordship. I think para 14.4, I think it has not been commented upon, Your Lordship. There is a quashing petition, Your Lordship.
High Court quashing, that has come. That separately be again the serial number. That is there. That has been included, don't worry.
Custody is only with the, my lord.
Both of you can see the draft order on Monday. Maybe, or today after lunch if you want to see, and then if there is any factual mistake, you can correct it before we sign it.
My lord, I have been told that the daughter is in the custody of the petitioner, respondent, and she will remain there, and there should not be any impediment caused in the sense that they should not approach the daughter.
We will not do anything.
All right. In view of the settlement between the parties, the girl child shall continue in the exclusive custody of respondent, her mother dash the respondent,
Please.
and the petitioner and the petitioners state that they shall not interfere in that exclusive custody of the respondent. पूछो क्या रहेगा इनका प्रोफेसर साहब का?
He wants to submit something. कुछ कहना चाह रहे हो क्या? Sir, actually, this cash bail bond requires presence of all the members. So can you please direct that?
Once we have quashed, then there is a question of presence of.
Yes.
In view of the fact that proceedings have been quashed and annulled, the petitioners are not required to remain, are not required to be present before any court or forum.
I'm deeply obliged.
None of the parties, my lord, in any case.
Deeply obliged.
Item 16. We'll take one non-miscellaneous day in next year.
Please, sir. My lord, item 17, my lord, deals with the issue regarding the non-notification of the cancer as a, my lord, notified.
What is the point, the doctor said last time?
This is something serious happening, my lord. Thank you, sir. Even, may I, my lord, because my lord has issued notice, may I say, sir, my lord, because my lord, the petitioner, my lord, there are the documents which show, which we have, my lord, filed in this, my lord, 98% of the my lord, population is not.
Place on record if you have any additional information, we'll like to examine it.
Please, sir.
That's why we are issuing notice.
Thank you, sir. Thank you.
As some eminent doctor has come forward, so therefore we will also like to consider it.
Thank you.
The issue is raised.
Please, thank you.
15,000 square feet of land is allocated, Malos, to a supposed newspaper. The High Court initially stays in 2011, and the impugned order, what they do, they order a direction that you check if the printing is happening there. They go there, printing is happening of about 3,000 odd. My all other allegations that the allotment itself is illegal, 42 lakh loss per annum to the this thing, nothing is even Malas taken care of in terms of even dealt with. On that basis alone is dismissed. I have Malas here a chart. I've prepared a chart of all the illegalities, and they're multiple.
Issue notice in front of you.
I'm grateful.
That's all.
Grateful.